All right. Well, I guess we'll go ahead and get started. People are still coming on, but we'll get rolling here so we can cover all the material. So I just want to say thanks to everyone for joining us today for 25 minutes with CapSpecialty, our first ever risk management edition. Looking forward to it. We recently published a white paper on social inflation, and you can find it on our website in the risk management section. In the next 25 minutes, or a little bit less now, we're going to get some perspective on social inflation from two people who are up close and personal on insurance claims and litigation. They witness it every day in the claims that they're handling on our behalf, and they do their absolute best to keep us in check. We'll wrap up the discussion with some thoughts on how insurance professionals can navigate these tricky waters. And I'll give you a little bit of a spoiler, of course, because I'm the chief underwriting officer for an insurance company. It's going to involve more rate, and it's going to involve less limits, lower limits. So today we're joined by my friend and colleague, Mary Haefer, who's our Chief Claims Officer of Property and Casualty for CapSpecialty. And then we've also got Adam Joffe, who's the CEO and Managing Partner of Goodman, McGuffey, LLP. And Adam is a valued partner on several complex claims for us. So welcome, Mary and Adam. Before we get into it, thank you. Before we get into it, we have a lot of good anecdotes and claims war stories to discuss, and we'll easily fill up the 25 minutes. So if you got any questions, please drop them in the chat, and I'll keep an eye on it as we go along. So let's get right into it. One of the acquired tastes of this industry is the infinite list of acronyms and abbreviations and buzzwords, and for at least the past 2 years that I can recall anyway, social inflation has figured prominently into that list of buzzwords. So Mary, how about you get us started by telling us our definition of social inflation?
Absolutely, Dan. Thank you. Yeah, we thought it was important for everyone here to kind of be on the same page when we're talking about social inflation, because you can define it differently. But most of us have been in the profession for a while, have dealt with claims. We understand the economics of something getting more expensive. You know, it's more expensive now to get treated for a broken arm than it might have been 5 years ago. So we get the economics. But social inflation is really referring to kind of what I call the soft or psychological factors of why claims values are going up. And that's really, what are the trends, the visions of our society that are influencing claim value. And we're kind of in a perfect storm right now. It's, you know, we have a lot of fairness issues, equity, social justice issues, technology issues, more and more people in the millennials, as we like to refer to on our jury. So all of those societal factors and trends are what make up social inflation.
Awesome. So Adam, building on this, what do you see as the top factors that drive up the value of a claim? And then let's hear how some of those factors are impacting a case that you're working on.
Sure. Yeah, sure. So I would say the number one factor that seems to drive, has, at least in my realm, in trying cases, that has driven up the value of verdicts just seems to be this generalized distrust of corporate America. The next topic would be, there seems to be also a desensitization to large numbers. Everybody seems to have a cell phone in their pocket, and we are constantly hit with the trillions and trillions of dollars that things cost. And as we see the country's debt go up and things of that nature, people have become familiar and comfortable with really large numbers. And then access to information. I mean, everybody's got so much information now, it seems like everybody is a bit of an expert, simply because you can pull your phone out of your pocket and ask Siri, and Siri gives you the answer. To give you a real world example of how this affected a case that I got involved in, I had a case where I got hired post verdict. So verdict came in $3.5 million on a case with $1 million policy. The defendant was a small kind of mom and pop refrigerated food service business. And the verdict was somewhat shocking. We had a very young plaintiff who had about $70,000 worth of medical bills and headaches. So out of the gate, nobody saw that as being a $3.5 million kind of a case. So I got hired after the verdict came in to help try and fix it. And in our research, what we learned was we had a somewhat of a bad corporate defendant. So while we would have expected a verdict to remain within the $1 million policy, the defendant who employed his son, his adult son, as one of his drivers, got involved in an auto wreck where the plaintiff was injured, and the adult son was found about a month before the accident happened, passed out on the side of the road with a hypodermic needle in his arm. And all of that information came into evidence, and the company owner testified during the trial and at his deposition that had it been any other employee, his son would have been fired. But because it was his son, he gave him a pass. So to start with, the jurors, having expected the corporate defendant to come in and already have been the bad guy, we had more evidence that the corporate defendant was confirmed to be the bad guy, which helped drive up the number. In addition to that, several of the jurors told us after the verdict that they had decided to give this young lady $1 million for a future brain surgery. And there had been no evidence in the case that she needed a brain surgery. All the evidence was that she had some headaches and headaches that would last for a couple years, and that was about it. But now that everybody has Siri to ask questions to, and they get information about very complicated topics, it seems like people have departed from relying on the experts in the case, and also the lawyers when making their arguments at trial.
Yeah, sadly, I think if you stick around this industry long enough, fact patterns like these, as crazy as they sound, they start to feel pretty ordinary, which isn't great. And Mary, I know you see a lot on any given day, and it's probably difficult to pick just one, but what have you seen recently that you put in this category of socially inflated claim outcome?
I mean, I think we're seeing it, frankly, on almost a daily basis, and it goes along a lot with what Adam was just saying. We're seeing it a lot in the context of like small insured, like daycare centers, and maybe habitational risks, like apartment complexes. And what we're seeing is this notion, and it's especially common among, again, I'm going to go pick on the millennials or kind of that group of jurors, but they're really into personal safety. They're very concerned about personal safety. So what the plaintiff's bar has done, even with, and it kind of goes along with the corporate distrust, even with that, it doesn't have to be a big corporation. Instead of having a jury or the fact finder focusing on that particular incident, like my child fell and broke their arm at the daycare when the teacher left the room. Instead of just focusing on that, the lawyers are using what they call the reptile theory, which is fear of flight, trying to make us angry, us as a juror. And they're saying, hey, it's not just about this particular incident. This place is a bad place. They're unsafe. They don't follow protocols and procedures, or they don't have any. So what should have just been a broken arm case, that value gets inflated because they go into the whole corporate distrust. You owe us as a community to make us safe, to keep us safe. They do it with habitational risks as well. My apartment complex better be darn safe all the time, not just from crime, but the premises better be safe. And they play on that. And so we're seeing that when we go to negotiate claims.
So it's, in other words, it's kids these days.
Well, yes, no. But I think what's important there is that we really need people to be on top of our insureds and what's really going on behind the scenes, because, the mom and pop daycare, do they have policies and procedures and things in place, or are they going to be made out to be this bad company, just like Adam was talking about with employing their son? Yeah.
So, having discussed some of the top factors driving socially impacted claim outcomes, a cynic might say, yeah, but, there have been unique and outrageous case outcomes through all of time. And in fact, volatility of claim outcomes is the reason we're in business. And I think, the line between what's always been and where we're heading isn't necessarily as linear as we'd like it to be. And sometimes I feel like anyway, you need to see what's going on by kind of reading the room, so to speak. And I'm interested in what are some of the words or explanations that you've heard given in the courtroom either by opposing counsel or even a judge that point to a disconnect between economic reality and justification for a gigantic award. Just real quick, I want to give one of my own examples. Several years ago, I did a lot of work for a large building products manufacturer that was navigating its way through a lot of asbestos liability claims. And in one of these cases where a gigantic award was granted to a case, a single plaintiff in Florida, the judge justified the award amount as being only a fraction of the manufacturer's revenue. Never mind the fact that they were losing hundreds of millions of dollars every year for several years in a row. So I just thought that was in the early days of just a disconnect between the litigation and the economic reality. Adam, what are your thoughts on this? What are you hearing?
Sure. So I was actually in court a couple of years ago in Clayton County, which is a county just south of Atlanta, here in Georgia. And the judge actually said from the bench, as we were talking about getting the case prepared for trial, that she didn't know why anybody tried cases anymore. And they had just had a couple months before that a jury reach a verdict of $1 billion in a tort claim. And I think at the time it was a record for the largest tort claim in the country. And it seems like that just to try and explain where we're getting these hugely disproportionate jury verdicts to what we would have expected even 5 or 6 years ago, it seems like that just the constant access to information that all the jurors have, especially our younger generations that are now in the workforce and business leaders, they're able to hop on their smartphone and get a lot of information, even during the trial. Most of the times, the judges are instructing the jurors not to do any research about the case at any point in time while the case is ongoing. But, they all have an iPhone or they have some other type of Android phone, and you can guarantee it that the moment they walk out of the courthouse and they get their cell phone back, they're on Google and they're looking up the insured, or they're looking up, the corporate defendant, and they're getting information almost real time as to whether or not, as Mary touched on earlier, do they have good safety ratings? What do they see on social media about them? So it seems like this immediate access to information is really what's driving, and whether or not the information is true or not, we don't know, right? Because it's just on the internet, but it seems to really be driving up the cost of claims.
Yeah.
I think going along with that, Adam, and you touched on it earlier, the desensitization to numbers. Everyone, I'm guilty of it. I'm a big sports fan. So I'm on, Twitter or whatever. I see this new contract that, so-and-so just signed for these, multi-million dollars over how many years. And I think we hear those numbers all the time, especially in the social context. And so when somebody asks for $1 million for a future surgery, it's like, well, okay, that seems reasonable.
Yeah, so these are great points, and so I'm going to definitely keep track of the time, because we do have a question that we'll get to. I do want to talk about venue a little bit. Venue has always been in the underwriter's toolkit when it comes to selecting and pricing risks, and avoid the places where trials and awards often end badly, and then lean into others where there appears to be more fairness in outcomes. I've been developing this for a while now, that in this digital age that we talk about, where borders and communities are becoming more abstract, that maybe venue selection is no longer an effective underwriting tool. But I think, Adam, you might set me straight on that.
Yeah, so that venue is the first thing that we look to when a claim comes in, or when we get a new suit in, as we start formulating sort of the process of coming up with a value for the case. We are looking at things like, is it in a rural venue? Generally, rural venues are more conservative. Is it in a urban area? Are you in a big city? If you were to look at the judicial hellholes publications that get produced on a yearly basis, you'd be able to see that the highly urbanized areas are where you get your largest verdicts. It also seems to correspond, and I don't know why, but it seems to correspond with the political map as well. In my own personal practice, that's the first thing I do. in Georgia, we have something like 170 some odd counties. And I grew up here and I've lived here my whole life. And I can tell you, I don't know where they all are. I mean, there are times where Mary may send me a case and I look at it and I go, where the heck is that? And the first thing I do is I hop on a county map and I look at the last election, and you can get really good numbers as to that county and how many votes went blue or how many votes went red. And that helps me understand the population in that particular area that's going to comprise my jury, you know, and figuring out the value of the claims. If I'm in a blue venue as opposed to a red venue, I'm going to expect the jurors to have a higher value of the claim. Just seems to work that way.
Yeah. Well, the good points. I will continue to study the abstractness of venue, but I hear your points and I heed your warnings. Okay, why even ask these questions? I think if you consider an emerging risk topic like silent cyber, for example, it's a new peril, relatively new peril that can be underwritten. The underwriter can exclude the peril, they can provide a specific sublimit, or take some other approach to controlling the risk. And by contrast, social inflation isn't a new peril. It's a reality that we deal with. It can't be excluded with policy language. So what can an underwriter do? From my perspective as a chief underwriting officer, I assume that when you're insured as a liability claim, regardless of what the claim is, the value of that claim is likely to be, bear some resemblance to the policy limit. So to put it plainly, don't be surprised when the opening bid to settle a slip and fall claim is a demand for policy limits. Mary, I know we've talked a lot about this in the past. What are you seeing in terms of trends in limit demands?
We're seeing a huge in limit demands, and what we mean by that is, early on, probably before a case is necessarily even in suit, but the injured party has retained a lawyer, we'll get a policy limits demand, almost out of the box, and we've hardly had time to even investigate, discuss with the insured anything, and really what they're doing there is not only trying to place kind of a floor on the value, but they also want to try to set up the carrier at this point to, if we don't respond quick enough and eventually there is a verdict or something that's over our policy limits, we're going to owe that on behalf of the insured. So they're trying to, set us up in a bad faith sort of situation. So we're seeing that almost routinely in certain jurisdictions. I think the emphasis, and for the underwriters and brokers to understand, is that's when we really need a cooperative insured, because we need to be able to get information quickly. If we don't respond to that policy limits demand quickly, again, we could be setting both the company and the insured up for exposure.
Yeah. So I think, here's the first takeaway for the listeners: manage limits carefully. If you're an underwriter, I think you've got to give equal consideration to both the upside and the downside when considering how much limit to offer. And if you're a broker, I think you need to understand and embrace why it's necessary to build a tower of limits with more carriers, maybe more so than it has been in the past. I think that, social inflation, in my opinion, it doesn't necessarily mean that the merit of a claim is no longer important, but it does mean that you better know you're insured before you agree to insure them. I think if the first time you're learning about your insured's blatant disregard for maintaining a safe work environment or living environment, product safety, and so on, is when the plaintiff attorney is detailing evidence of that bad action to a jury, it's probably going to be a pretty tough outcome. Adam, I know you talked a little bit about the instant availability of information. Any other thoughts to add on that?
Well, the first thing I would do is Google the insured, if Google is a verb. But what you want to see is like what's out there, and so many things are now available online. It seems like every agency that kept information on any type of corporation or industry practice or regulation has been scanned and is now in a database and is now publicly available. I think you need to search the industry regulators for the insured that you're writing. I mean, I would do this on a client when they come in, and I want to see what their safety rating is. I mean, all that information is now, like I said, available online, and I can tell you if I have it, the plaintiff's lawyer has already had it for the last year or two, So they know what they've gotten into well before I can even get my head wrapped around what the case is about. So that is just easily accessible information that I think anybody can get their hands on. Helps get a good picture of the insured from the very beginning.
Yeah.
Going along with that, Adam, it's, you know, something as simple, and you alluded to it earlier, the social media. You know, let's say you insure a small restaurant, or you're working with, you know, go on, see what their Yelp reviews are like, because that may also trigger a, hey, is this a place that doesn't follow their own policies and procedures, things like that. So you're not just checking boxes, looking at the application for this insured. You're really trying to understand so that when they're sitting next to you at the defense table, you've got a good story to tell that we're a good insured, a good safe place.
Awesome. So, hey, in our last few minutes here, I'm going to start hitting people with some numbers. So people that hung in there for a little bit, you're either going to like this or not. You know, I think these are great points. And in our paper, we referenced survey results from Magna Legal Services, where I think it was 81% of the people responded that they believe corporations care more about profits than they do about people. And I think it's important to understand that, because, you know, the insured will not be entering a courtroom with any benefit of the doubt that will work in their favor. I think that's a good takeaway. So what I want to you know, start to close out with here is pricing of liability risk. Liability claims develop over many years. An accident that occurs today may not turn into a claim for several years from today, and the resolution of that claim may be even longer than that. And I believe when a jury is deciding how much to award on a claim, they're not reducing the amount of that award because the accident happened 5 years ago. It's whatever today's dollars are. So, you know, I think the takeaway from there is, did I get paid enough 5 years ago to cover claims that are getting awarded today? And then by extension, am I getting paid enough today for claims that I'm going to be paying 5 years from now? So I think those are important things to remember. In our paper, we note how frequently over time a claim includes a policy limit demand. And even though, you know, the overall number relative to the total number of claims is relatively small at less than 3%, that's actually 40% higher than it was 5 years ago. And I think, you know, both Mary and Adam talked a bit about this throughout the discussion today. And then furthermore, when you have a large claim, the average value of those large losses is rapidly pushing up against the policy limit that's available. And you can see that in the numbers as well. And to say it another way, even though I think average loss cost trend may appear to be a manageable 3 to 4%, call it, the volatility of the loss cost trend may be increasing, and that needs to be accounted for in how you're pricing and selecting risk, I think. And I think that leads to the third and final takeaway. Just don't sell yourself short when it comes to time to pay the claims. Make sure you're charging adequate premium. And I think you know, we need to be leery of our own tendency and of others to sell cheap capacity, because it's, you know, someday that will come to roost, I think. We have 1 minute, and there was one question for Mary. When it comes to negotiating claims, how do representatives understand key items they need to make a decision for a claim to be approved or rejected? Do they have to go through multiple systems to make that decision?
I'm not sure I completely understand the question, but you know, when the claim adjuster is negotiating the claim, you know, there's different areas here, whether it's a litigated claim or they're just working directly with the claimant. But, you know, we do ongoing training about all the different factors to look for with respect to how to get to that end result, and taking into account all those things that we've been talking about, like, you know, who is our insured, you know, trying to think long term, how we best position our insured. And of course, you know, we've got oversight with the insurers, et cetera.
Right, absolutely. Well, hey, listen, it is 2:25. Remarkably, 2:25. We kept it exactly on track here. And so, Adam and Mary, I just want to thank you again for your time and valuable insights. And I really look forward to discussing the next risk topic. And then to everybody who dialed in today and listened, thank you very much, and thanks for supporting CapSpecialty. But thanks, everyone.
Thank you. Thanks for having me.